Let's start. Anyone listening? Is everything working?
I can hear you, but I don't know if...
I think we should start. I'm getting messages. Yeah. Well, we shall start. Well, you can follow the professor. You can follow what I'm going to say in the chat, but I'm going to proceed in Portuguese for the viewers. But é com a mais sincera e manifesta admiração que eu venho no presente momento apresentar a vocês o professor Alon Harel, e desde já eu peço desculpas pelo minha pronúncia em hebraico. Os seus feitos e seus trabalhos, eles já falam por si mesmos. Ele fez doutorado em Oxford, foi orientado por Haas, que eu não preciso nem apresentar ou qualificar. É professor na Hebrew University of Jerusalém, em Tel Aviv. Foi visiting professor em instituições como Harvard, Columbia e várias outras, assim, que... Em suma, é bem mais fácil eu passar para vocês o link da Wikipédia dele do que listar todos os feitos objetivos que ele fez, que o professor Harel fez. Contudo, o que eu quero realmente exaltar e destacar é a postura dessa pessoa que nós iremos ouvir. O professor Harel, Alon, ele tomou certas atitudes e atitudes públicas e atos que eu reputo por excelência ser a tarefa central da atividade filosófica. A dizer, o ato de revelar ou mostrar fatos ou verdades que são absolutamente inconfortáveis para qualquer pessoa. Nesse sentido, eu acho digno de mostrar só como isso já aparece claramente de cara em Platão, no mito da caverna, que todo mundo conhece, mas provavelmente nem todo mundo vê como ele termina, que é com um verdadeiro dilema moral e de implicações políticas extremamente severas. O que acontece no final do mito? A pessoa que viu a luz, quando ela retorna para a caverna, ela se encontra diante do seguinte problema. Ela fala para os outros acerca da verdade, do que viu fora da caverna, nos termos do Platão, de dizer a verdade dos outros, e com isso ela possivelmente vai ser sujeitada a ser taxada por louco, vai sofrer ostracismo, até ser morto por pensar diferente, porque é um fato, todo ser humano odeia quem ousa ou pensa de modo diferente. Então, essa pessoa que viu a luz, ela tem o dilema, ou ela tenta iluminar os outros, ou simplesmente ficar quieto para se autopreservar. Isso é um dilema tanto moral quanto político. Então, o mito, ele culmina nesse dilema, que é o dever moral de tentar educar os outros e mostrar a luz em face do perigo absoluto político de ser rejeitado ou até eliminado pela própria comunidade que o personagem do mito tenta iluminar. Para mim, essa é a tarefa por excelência da filosofia, a tarefa de expor fatos que são desconfortáveis. E fazer isso é algo absolutamente abominado por qualquer pessoa normal. Aquele que ousa pensar ou seguir o que a moral lhe manda é sempre e inevocavelmente execrado por todos aqueles que nunca pensaram ou sequer fizeram alguma reflexão moral ao longo de suas vidas. Eu posso citar Bertrand de Juvenel, que ele fala com todas as letras. O homem não busca a verdade, ele se choca contra ela. E é simplesmente inquestionável. As pessoas não querem ouvir a verdade porque elas não querem que suas ilusões sejam destruídas. O professor Harel, assim como a Hannah Arendt, ousou se manifestar possivelmente acerca da questão mais sensível de seus tempos. E nesse ato, tal como a filósofa Hannah Arendt, que foi severamente retalhada por muito do seu próprio povo, o professor Harel se submeteu a isso. Tudo isso pelo simples fato de, usando o termo de Kant, ele ter ousado sapere aude. O sapere aude já está, ouse saber, né? Que na verdade o significado é ouse saber por si mesmo, né? Não simplesmente reproduzir o discurso padrão e afim. E nesse ponto eu abro um pequeno parênteses, porque como a minha área é filosofia moral, eu me sinto sempre obrigado a alfinetar certos aspectos. Nesse ponto do sapere aude, acho que quase todo mundo conhece um artigo do excelentíssimo ministro Barroso, que escreveu dizendo que o STF seria a vanguarda iluminista brasileira. E com todo o devido respeito a Vossa Excelência, ela não se destaca pelo seu notório saber jurídico, mas sim pelo seu analfabetismo. O sapere aude do Kant simplesmente exclui que a gente seja guiado por seres supostamente iluminados, que é um atributo que Vossa Excelência, presume possuir. Mas, né, enfim, fechando o parênteses, o professor Harel ele realmente ousou fazer isso. E especificamente devido a isso que eu tenho a profunda admiração e verdadeiramente me sinto honrado em apresentar o professor Alon Harel. O termo filósofo eu reservo para um grupo extremamente seleto de pessoas. Mas eu realmente não posso negar que as atitudes do professor Harel, com quem nós temos muitos a aprender nessa oportunidade ímpar de ouvi-lo, as atitudes deles se caracterizam e se destacam como absolutamente emblemáticas. Elas constituem a prova viva do seu engajamento no que eu considero ser a tarefa por excelência da filosofia. Então, com vocês, eu deixo a palavra ao professor Harel. I give you the words, professor, and it's I believe you read a bit of what I said, but it's with the highest esteem that we can hear and now learn from you.
No, thank you very much. I appreciate the invitation. I don't see Jose here. I don't know. He may be around.
He is coordinating everything in the.
Okay. Simply, I see you and somebody called E. That's all I see. But I hope.
Yeah, me neither. I would rather see more people. So it's hard to communicate, to talk alone.
Yeah, I just want to make sure that he's around. But yeah, okay, good. So I'm very happy to be here. I've never been in Brazil, but I hope to be there. I've been in Argentina. Next time I'm going to South America, I will make sure to be in Brazil. I'm going to talk about half an hour, maybe hopefully even less, and then we can have a discussion. And what I'm going to talk about is what is a normative core of constitutionalism? What are the distinctive features of a constitution? When we speak about tort law, and we often speak about tort law as designed to guarantee equality, liberty, whatever. But with respect to constitutionalism, there is a very serious problem because constitutions includes provisions that protect rights, that establish institutions, sometimes that establish particular language or religion or historical narratives. And there is nothing in common with for all these features of a constitution. I'm going to start by saying that there are two features shared by constitutions which merit attention, and I think that ultimately provide the key to the understanding of what constitutions are. First, the norms and values that the Constitution contains are conventionally viewed as important, foundational, indispensable to the governance and life of the polity. When we say that a norm is a constitutional norm, we typically assert that it's a very important norm. Secondly, when we speak about constitution, we also think that it's typically very salient. People know about it. It plays a role in the life of the polity. And norms, constitutional norms, do it by virtue of their visibility and presence in public life. People know about the Constitution. They don't know the details, but they do know the general scheme. I think that when we look at these two characterizations, we find the key to understanding of what constitutional law is about. Constitutional law contains norms whose values and good can be realized only if recognized by the public and internalized by the public. Let me summarize this in 3 sentences. There are norms and values that are particularly important. At times, they are not only important, but it is also particularly important to highlight their importance, to amplify their salience in the polity, to bring their prominence to the forefront of public life. Constitution contain those norms and values that need to be publicly recognized as important. Hence the subtitle of this article, on the importance of being recognized as important. Let me provide you an analogy. We can speak about paintings. Paintings gain their values only if they're, according to many, I'm not an aesthetic expert, but very often you say that many people believe that paintings gain their value only when they are being realized by people, appreciated by people. Similarly, I think that the Constitution contains norms and particular values that can be whose value can be realized only if they are being appreciated by the public. Note that this characterization does not make any assumption as to what the particular norms are. Some people may argue it is important to stress the public institution, to reinforce democratic participations. Others may stress the value or the role of human rights. What unites all these cases is the perception that public salience and prominence and the role that such prominence plays in fostering civic engagement on the part of citizens. Now, I want to stress something that I think is very important. This account of a constitution is not a definition, and I don't say that any provision in any constitution is one that meets this requirement. I only argue that this is a feature that is unique to constitutions, and that there are norms and values which, to be efficacious, need not only to be conformed with by the people, but they need to be publicly acknowledged, internalized, engaged with, affirmed, endorsed. Constitutionalism is a framework through which societies typically designate certain norms and values as fundamental. The rationale underlying this is the need to elevate their visibility, increase the prominence of the constitutionalized norms and values, heighten their salience, and affirm their distinct value. Why is it so important? Why is it important not only that there will be a public institution, that rights will be protected, and so on and so on? What I argue is that there are norms and values, that it is very important to engage with them in order to realize their value. I want to cite here a short paragraph from Joseph Raz, who happened to be my supervisor, who passed away a few years ago, a very prominent legal philosopher. He famously argued that ultimately the value of object in general is a byproduct of recognition of their value. And he says as following: the value of objects remain unfulfilled, if not valued, is explained and further supported by a familiar fact that an object has value can have an impact on how things are in the world only through being recognized. The normal and appropriate way in which the value of things influences matter in the world is by being appreciated. So people need to recognize the value in order for the value to be realized. I want to apply this observation to real constitutions. And I shall argue that the three principal domains constitution typically regulate, and this is the establishment of governing institutions, the establishment of the president, the parliament, the courts, and so on, so on. The protection of fundamental rights and cultural and national identity are inherently linked to prominence and salience. The success of regulating these domains hinges on the public recognition of their importance, which gives rise to active engagement on the part of the public. Such an active engagement is what I call a transformative engagement. It transforms people into citizens, citizens into right holders, and at times right holders into members of a particular culture or nation. Our public institutions require active engagement because as citizens, we are expected to take part in public institutions, makes use of them to promote the public good. Granting constitutional recognition to public institutions transform people into citizens, governing their polity. Rights gain their significance when individuals actively exercise them, and exercising rights presupposes active engagement that turns people into active right holders. To bring an example, the right of free speech. The right of free speech is valuable only if people exercise this right. Without valuing this right and engaging with it and exercising it, the right is not valuable because the value of this right is focused on the fact that people exercise free speech. Last, national or cultural narratives like language, religion, historical narratives, and so on, are based on transformation of people into members of a cultural community. People need to engage with it. The fact that the Constitution says that language is X and the religion is Y and so on, is not it does not realize its value unless people engage with this historical narrative, regard themselves as part of the collective. Let me elaborate on this. Okay, so the first dimension is governing institutions. It is common to say that one of the features of every constitution is to establish a government, courts, presidents, and so on. Some even maintain that creating, structuring, and defining the limits of government power or authority is what defines constitution. This is what constitution, in the most minimal sense, is. In democratic regimes, such institutions need to be salient. To facilitate democratic governance, knowledge and understanding of the institution is a necessary but not a sufficient condition. The role of the Constitution is to guarantee the prominence, salience of public institutions in the public sphere. Such prominence is necessary to facilitate and induce active engagement and political participation. It is designed to turn people from mere individuals into citizens who govern themselves, namely transform them into participants in the governance of the polity. Transparency, namely people know how these institutions are structured, provides citizens with information, but it must be coupled with participation. By doing so, people are being transformed from mere people individuals into citizens who are engaged in governing their polity. Now, what does this have to do with constitutionalism? The answer rests on my general understanding of what constitutionalism is. The incorporation of provision concerning the structure of public institutions and the labeling of these institutions constitutional serves not merely as a formal label. It's not just an accidental label. It is designed as a means to make the modification of this institution more difficult by endorsing stringent procedure of amendment. It is designed to affirm publicly the fundamental significance of this institution within the political and legal order. The labeling signals that these institutions are not just functionally necessary, but they merit active engagement. In this way, constitutional recognition of public institutions does not only reflect their importance, it actively shapes the way they are publicly perceived and the way they are embedded in public consciousness. So this is the first element, the first dimension that all constitutions contain. And what I've tried to show is that only when people engage with these institutions, regard them as valuable, regard participation in them as valuable and shaping them as valuable, the value of these institutions is being realized. And that's what makes them constitutional. Constitution often contains Bill of Rights. The question I address here, however, is whether, and if so, it is not only important to protect rights and transfer them in the document, endorse stringent procedure of amending the right, but what makes this provision ultimately constitutional? I will argue that what makes rights constitutional is precisely the fact that they merit recognition as important and prominent features in our public life. And it is only through public recognition of their prominence that citizens can effectively exercise their rights. The protection of constitutional rights thereby transform individuals to what I label appropriate right holders. I start by establishing the constitutional right to not only protect activities that exist independently of their protection. What constitutions do is highlight the importance of rights in order to stress the value of engaging with rights and reinforce their exercise. In doing so, constitutions transform citizens into appropriate right holders. To successfully do so, they need to be recognized as important by citizens, as valuable, in order to engage with them, to exercise them. Autonomy, let me apply this general observation to the case of what I label autonomy-based right. Speech, religion, movement, association, and so on and so on. Autonomy makes people's life better if and to the extent that they exercise it in their life, that they make choices. To do so, they need to realize that the exercise of autonomy is valuable. Further, the choice to exercise autonomy ought to be informed by appropriate reasoning. Appropriate reasoning is one that satisfies minimum requirements of rationality. A person who chooses his political views on the basis of the physical attributes of the candidates, namely whether the candidate is handsome or ugly, fails to exercise autonomy or to exercise autonomy in a rational way. Acquiring the skills to exercise autonomy requires a certain environment that is conducive to it. A person can be asked to choose a political party, a spouse, or a career path, but not any choice would count as an exercise of autonomy. To exercise autonomy in an appropriate way, one needs to know what criteria the selection of spouses, professions, or political platforms ought to be based on. Could I autonomously follow blindly, without reflection, the spouse that is favored by my parents or by my religious authorities? Could I autonomously vote blindly for the political party that has been recommended to me by my religious instructor, psychologist, or my spouse. Are these choices autonomous? I would say that even if they are autonomous, they are not a proper exercise of autonomy. Constitutional entrenchment of rights constructs a common culture and facilitates the exercise of autonomy by protecting paradigmatic cases of valuable autonomous choices, denying protection in cases in which the decision was not reached in the designated way, elaborating the rationales underlying these decisions. The Constitution contributes to the very formation of autonomy-enhancing practices and to the very transformation of people into appropriate right holders. The autonomy-enhancing potential of speech or any other choice hinges on sustaining practices that stress the importance of choices, dictate the way in which these choices ought to be made. The successful engagement in autonomy-enhancing activity needs to be nurtured. To be nurtured, it needs to be engaged by citizens. And this engagement is facilitated by stretching the importance of exercising rights. So the Constitution stresses or makes salient rights in order for people to be engaged with them and thereby to facilitate the realization of their values. Last, I want to show that the same consideration explain why some constitutions include what I call particularistic norms. Particularistic constitutions refer to constitutions with stress characteristics such as language, religion, historical narratives, and so on. Now, I do not deny there are problems with such norms, with such values, and the reason, of course, is that often such constitutions alienate people who do not belong to the majority religion or language or whatever, and therefore creates stress and conflicts in the society. So in Israel, for instance, the definition and characterization of the state as a Jewish state is one that alienates Palestinians who are also citizens here and perceive themselves not to be part of the state, and this is a problem. But I'm not going now to argue whether particularistic constitutions are justified or not. I just want to show that the method that I use can explain also particularistic constitutions. Particularistic constitutions are those constitutions that contain provisions that explicitly engage in developing national and cultural narratives. Unlike purely proceduralist or universalist constitutions, which focus on structuring government and protecting individual rights in abstract, neutral terms, particularistic constitutions actively affirm and enshrine the identity, heritage, and values of a specific ethnic national group. Such constitutions often articulate historical events, contain national aspirations, remind people of collective memory, emphasize shared traditions, and so on. What is the ultimate purpose of incorporating national narratives in the Constitution? It seems evident that the inclusion of national narratives in a Constitution is designed to promote and reinforce a cultural national identity. By embedding historical accounts, cultural tradition, or ethnic markers within the constitutional text, states seek to solidify a collective sense of belongingness and unity. The success of incorporating national narratives in the Constitution hinges on the degree to which the Constitution succeeds in making national identity salient and prominent in the public sphere, and thereby fostering its integration and dissemination by citizens, and consequently transforming people into members of a particular culture or nation. Now, I want to say a few words about the question which I assume may be of interest, namely, but does this really describe real-world constitutions? What I showed is that fundamental domains commonly regulated by most constitutions are ones that fit this analysis. In other words, are ones that require engagement on the part of the public. And the Constitution is the constitutional law is the method, the means by which certain values are being become salient in the public life of a nation, and thereby that people can engage with them and thereby realize their values. And this is true both of governing institutions, the president, the parliament, blah, 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 and autonomy-based rights, that needs to be exercised in order for their value to be realized. And last, also, it fits the particularistic constitutions, because those who want particularistic constitution, I don't say whether they're good or bad, but those who want them don't want them to be merely letters or words on a document. They want them to be ones that people will engage, internalize, debate about, realize in their lives, and so on. So this in itself is an indication that it fits to some extent. But of course, there is a manifest divergence between the public constitution and real constitutions. What I want to show now very briefly is that when there is a rift, when there is a divergence between the public constitution and real constitutions, both courts and theorists makes effort to repair the constitution, to amend the classification of norms and practices, either by labeling provisions as constitutional, even though they don't formally belong to the Constitution, or by practically excluding provisions which formally are classified as constitutional. So one way to do it is very often by using terms like super statute, constitutional statute. So to bring you an example that is used in the paper, the human rights laws of the 60s in the United States, many people regard them as constitutional. They are not formally part of the Constitution, but they are being regarded as constitutional statutes or super statutes. This also explains the recent popularity of classifying statutes in common law jurisdiction as constitutional, despite the fact that the absence of formal entrenched constitutional text. This is true in Britain, for instance. In Britain, the courts decided to call certain statutes constitutional, to grant them special status, even though formally they don't have a constitution. The public constitution is that constitution that invites citizens to participate in the public life of the polity and transform into citizens who participate in governing their polity, into appropriate right holders who exercise their legally protected rights, and also in the relevant jurisdiction, transform them into members of cultural community. To successfully do so, the public constitution must stress the prominence of the norms and values it contains. It's a means of communicating to citizens that they should regard them as important and consequently deserve to be the focus of their attention and active engagement. The Constitution, therefore, works by persuasion, by winning the hearts and mind of the community it creates and regulates. The most fundamental concern of the Constitution is to mark certain norms and values important, to make them salient, to amplify their presence in the public sphere, and enhance their visibility. The importance of being publicly recognized as important is a fundamental motto capturing the spirit of constitutionalism. This characterization has an explanatory force because it explains the three dimensions I talked about, and I think it also shows distinctive normative value of constitutions. Thank you very much for your attention, and I'm looking forward to the discussion.
Professor
let me just say one word. It is part of a book I'm writing now on the public constitution. So there are many chapters of this book, and I hope to finish it in 6 months or so.
Very nice. Professor Harel, thank you very much for an excellent lecture and for sharing your ideas with us today. Your way of thinking about the judge's role, starting from the moment a person decides to become a judge, was very original and, if no doubt, helped us to see the problem in a new and clear way. We are also very happy to have you with us today in our event. Since our first conversations, you have always been kind, helpful, very available, and it has made everything much easier for us, for our team. Your presence means a lot of us, and we are especially happy to see such a large audience today, with almost 200 students watching at the same time.
Oh, wow.
And I must say, it's not easy for me to pronounce it Harel correctly. I heard that it's not easy for you to pronounce the A of my name too. So I think we are at least even, right?
Thanks.
But your idea that judges may change the meaning of the law in order to make it just bring us to an important question, and permit me to share with you. On that has been widely discussed in Brazil in recent years, to be honest. When judges give the law a new meaning to make it fair, how is this different from the whole of the lawmakers? And how can we make sure that judges do not gain too much personal power with this attitude?
Yeah, I presented a different paper perhaps than I gave you, but I will address this question. Yeah, I have it. I'm sorry, I wasn't aware that I gave you a different abstract, but the answer is very simple. I think the core of the paper that I sent the abstract of is that no person can commit herself to become a judge unless they have the power to change or to rewrite the constitution or the fundamental laws, because a person cannot commit to apply an unjust law. This is the core of the other paper. And the answer to your question is very simple. I think that the public cannot expect judges to do things they are not entitled morally to do. If the public or if the polity does not accept this, then no person could become a judge, because no person could apply an unjust law. And therefore, I think that now we cannot guarantee the judges will not abuse this power. This we cannot guarantee. We can only guarantee that, but the fact that we cannot guarantee abuse doesn't mean that we ought not recognize it. Also, interpretation can be abused. Judges can lie about what they say. And therefore, I believe that the risks of manipulation, the risk of mistakes on the part of judges is not an argument that can overcome the duty of a judge not to apply what I call their flagrantly unjust laws. I hope this clarifies this point.
I don't know. We have a line here for questions. We can't see the viewers, and can I say, Jose and Professor?
Yes, please. I received 4 questions.
Oh, but can I say first, or?
Okay, it's possible.
The first thing I would point out is that what Jose bring, it's a particular problem in Brazil. That's because basically the monopoly of the Constitution was took by the lawyers and the judges. So the principles like the dignity of human being, like, I don't have a single say about that, but those illuminated beings, they know what that means, and they use that for deciding A or for deciding against A. So that's basically a sociological, political position that we face, and that's the very point that I believe that made Jose bringing that question at first, in spite of your lecture was different. But I would really summarize like your view in the previous paper is that it's the what Tomás Aquino says that Lex Newson Lex had the quedam violentia, an unjust norm or lex law is not law, but violent, sort of violent. And is it a problem that I'm using only English and Jose? But well, no one that commits to the public role of applying rule would actually accept applying unjust rules. Like it makes total sense. Your argument.
I think that we have a question very similar to this. Permit me to do it together. And I don't know, the title uses the word rebellion, and rebellion was very interesting. Everybody loves a rebellion, right? But how far can this necessary rebellion go? And the question is, how can a judge know when it's right to change the law and when it is no?
Yeah, I mean, this is a real question. The real concern is abuse of power. I mean, this is a general question that does not apply only to judges, because what I say in this paper is that normal citizens very often need to do acts of civil disobedience. I think almost every philosopher now and almost every citizen believes now that at some point people need to refuse to obey the law. Now, the problem is that it's a person herself needs to make decisions with respect to it. And those decisions may be wrongful. To bring you an example, public officials in the US refused to register gay couples because she thought that this is against God's will, or whatever she thought. I don't know, not sure. I can say she was wrongful in her decision, but I do think that every person must have some boundary, even if this person makes wrongful decisions. Even if this person makes wrongful decisions, it is still important that she will not apply rules that are unjust. And this is a power that cannot be denied to a person. What I say in this paper is that judges are unique in the sense that they have to apply the law. And I want to reconcile the idea that they have to apply the law, but and they are bound by the law. At the same time, they are not supposed to apply unjust laws. They shouldn't apply unjust law. How do you reconcile this? And what I'm saying is that you reconcile these by granting judges the power to change the law, to rewrite the law, even the most fundamental laws. The fact that there is a risk of abuse, manipulation, is true about civil disobedience. It's true about the doctrine that I am trying to develop. The only question I think that this gives rise to is a question of whether what are the type of risks that the judge should take. Should the judge be very risk averse and say, I obey the law as long as it is not evident to me that it is flagrantly unjust? Or should the judge say, I should rewrite the law even if there is some probability that the law is unjust? And here, maybe in order to prevent the institutional problem that you raised, namely the problem of manipulation, perhaps judges should not take risks. They should obey the law unless it is very evident to them that the law is flagrantly unjust. This minimizes the risk of the institutional risk. But without this, how can let's say I commit myself to do whatever you, Jose, tells me, whatever you tell me. And then you tell me, can you kill, I don't know, someone? And of course I can't do it. I cannot commit myself to this. And therefore, we should presuppose that in any such commitment, there is an exception. And this is true also about the case of law. Because when a judge enters an office, he or she doesn't know what rules will be legislated, what the legislator will do. The legislature can do whatever it wants. And therefore, it's precisely like a commitment to do whatever Jose tells me to do. And that's a commitment I cannot make, and I think a judge cannot make.
Can I make a question about what you actually presented, Professor?
Yes, I will be very ill.
First, I will ask if my reconstruction of your argument follows. It's kind of hard to frame because I was writing everything in two languages at the same time. But just to make clear, your conception of a law, of constitutional law, highlighting this aspect of being commonly valued by people and commonly recognized, can be seen as only formal view of the law. By that, I ask. It doesn't need to say anything about the exact content of the constitutional rules. It's just a common feature that it has to be, but it doesn't say that we have to have free speech. It's just like a formal aspect. Could I reconstruct your argument in the sense that it's a formal aspect of constitutional law, that it has this feature, or it goes to the material sense of constitution?
Yes, you are precisely correct, 100%. It's a formal feature. I don't say whether there should be free speech or not. I think also that constitution could contain norms that are really bad norms. I don't know, perhaps in some constitution, you're expected to believe in God or whatever, to have certain belief. But as long as the perception is that in order for the good of the value to be realized or the norm to be realized, it needs to be recognized and engaged by the public. This is what makes it constitutional. It doesn't say it's a formal feature and not a substantive feature of the law. Yeah,
that was basically like with the introduction for my question. But it was like if I had like the correct view, so so I could continue the argument.
Yeah.
I don't know, Professor, if you're well aware of Lon Fuller, Internal Morality of Law.
Yeah, I'm aware of this book.
Because reading your view in the way I did and in the way you express it, when you see if you see constitutional values only being realized if they are commonly understood and minimally recognized by those who the Constitution address, it can be seen as like a sociological and even epistemological extension to Lon Fuller argument of morality of law. Taking as the basic premise that the morality of law of Fuller says that law has the enterprise of subjecting human conduct to the governance of rules. In some of the 8 desiderata, for example, when he says about he never says explicitly what you said, like you're bringing something absolutely new, but it could be inserted into the general Lon Fuller theory, at least in my view. For example, when he says about generality, generality says that rules must be general and not ad hoc commands. But generality allows people to recognize themselves as subjects of a constitutional order. Then what follows? Only by this that constitutional values like equality, limits of powers can be appreciated as common principles, and by I mean commonly appreciated by the community. If they are seen as having this common value, if they don't have, they are just isolated derivative. The same could be said about when Fuller says about prospectivity. The law can only direct the human conduct if people recognize the common value of those norms to direct them. Makes sense? Anything that I said, or
yeah. In my view, it's a very good point. I thank you for this, and I'm going to mention it in the chapter. I think the difference is, there are 2 differences. One is Fuller speaks about law in general, not about philosophy. And therefore, the requirement that he introduced a requirement of knowing the law, not appreciating it, not engaging in it. The difference is that I think with respect to constitutional law, the value is being realized only when you are engaged with this. So only when you feel the institutions or my institutions, I want to be involved in them. I want to participate in them. I want to make them better. The same thing is about exercise of right, the same thing about particularistic constitutions. Yeah, it's a good point. I think that in Fuller case, it's the knowing is important. I am entitled to know. Law.
Or if it's possible, or like there you can follow a law that says you must fly.
Yeah, you have to know the law. And I guess the law also, you have to be able to follow it, but you are not supposed to accept it, internalize it, engage with it, this type of mental things that you're not,
But it was absolutely fascinating, your view. But I know that Fuller has a different scope than yours. It's focused in constitutional law, but at the same time, I can draw some parallels and see how it can expand even Fuller's idea of the general concept of law, because it highlights a feature that Lon Fuller didn't didn't do, and you're doing it now.
But I think it's justified to say that the difference between Fuller analysis and my analysis is rest on the fact that I speak about a specific dimension of law, one that is very salient, one that is very.
But at the same time, your view kind of brings more content and more makes Lon Fuller general idea even better.
Thank you.
That's why it's fantastic. If he had read you, he would definitely mention you and highlight these points that are not explicit.
Yeah, I will look at it. I think it's a good point. I mean, in the paper, I try to develop what the mental state of engagement requires, and this is something I have to develop. And I think contrasting it with Fuller is a very good idea.
Thanks a lot, Professor. It was an honor to hear you the entire.
No, I'm really sorry that I forgot that I sent you something that.
Well, both papers were very, very interesting to us. So you contributed twice instead of making a confusion. You just gave more things to think about and to engage with.
I think perhaps the paper on the judges perhaps is more relevant to people who engage also in practice, because in Israel the debate about judges cannot do it, they can't make the law, but if they can't make the law, how can they submit their candidacy to become a judge when they don't know? It's like me saying to you, I will do whatever you tell me, without knowing, without putting any limits on this power. I think it's absurd to require judges to make this commitment.
Perfect. So thank you, Professor, again for your time, your ideas, and principally your generosity in sharing your works, to be honest, with us. Agradeço a todo mundo que tem nos acompanhando, professor Guilherme, professor Alon, né? Tivemos um público recorde de agora 594 pessoas acompanhando ao vivo, né? Bastante expressivo. Então, agradeço novamente a todos.
600 viewers at the same time now.
Eu não ouvi.
Yeah. And I'll be happy to be in touch. Perhaps when I'm in South America, I plan to go to South America at some point.
If you go to Argentina, we are really close.
Yeah, I know. I will go to Argentina because I have a book called Reclaiming the Public that came out last year, and it's being translated into Spanish. So when it is being translated, I probably will go to Argentina. Because I've been there.
Yeah, an honor to see you in person and to learn more.
Yeah, we'll write you. Yeah.
Welcome to Argentina. Come to visit us too.
Yeah,
and we have the same kind of barbecue. We have almost everything that we just don't have tango here.
That's okay. I don't dance. I have a friend, George Fletcher, who is a professor, quite well known in criminal law, and he loves tango for some. Yeah.
I do love because of Scent of a Woman. That's one of the greatest scene of the movies and cinema at all. At least for me.
Yeah, and do share if you have something about the Brazilian Constitution in English. I would love to see it.
Actually, this point is so problematic that it's even would be easier to tell you about the Brazilian particularities speaking than writing, because we live in a hell, basically.
I thought you just had a quite positive change in the government. I don't know what this did not affect.
No, in Brazil we have like as in North America, the diffuse, the non-concentrated control of constitution, and we have at the same time the concentrated. And basically, the judges have the complete monopoly of law. And in Brazil, we have like this. It's part of the constitution that the Supreme Court can say that an amendment to the constitution is unconstitutional, and prevent.
The Indian doctrine of
only Brazil and India have this atrocity. But if you think like, why do we have to change something in the constitution? Well, because that doesn't fit with the constitution, right? Otherwise, you wouldn't have to make an amendment.